Talking with a little bit of annoyance today, there's a framework within the Taxes Management Act that allows HMRC to operate within, and it's also for the taxpayer or for us agents to operate within, that gives the parameters of where you can settle your tax liabilities. This might sound something very sort of odd, but this framework basically means that if you haven't had if, as a taxpayer, you haven't undertaken a conduct that could be regarded as deliberate, then the time for you to be inquired into if you've submitted a tax return is limited. HMRC cannot make something called a discovery unless they can prove something that is deliberate, or if you haven't submitted a return, then you could be open as well, because if you don't submit a return, then you've done a failure to notify, which could mean HMRC go back over 20 years. But just looking at that non-discovery for deliberate conduct, and there isn't a deliberate conduct, then this framework exists that limits HMRC to assess only within the parameters of them raising inquiries to what they call open years. If your year cannot be inquired into, you cannot open it unless there's a discovery, and if there's a discovery for non-deliberate, it's limited to 4 or 6 years only. And I'm not going to go into specifics of the circumstances, but the reason I sort of make the video is that recently we've had an onslaught of HMRC trying to argue that where a taxpayer hasn't settled in respect of years that aren't open, so not subject to inquiry and they can't discover into, in order to get a settlement, they should make something called voluntary restitution. This means pay the tax for years that they technically don't have to because they're not within a legal framework. More interestingly, the officers on these cases have turned around and actually said, we are not going to settle these cases, or it is not our policy as HMRC, so wider than just the officer, to settle on this basis unless you undertake voluntary restitution. So my warning today out there to all of you is that HMRC don't have a legal right to force a taxpayer to voluntarily restitute. It's not within the legal parameters of the legislation. In order to do that, they would have to identify that they could discover, and for a period of up to 20 years, they can do that if there's deliberate behaviour. If there's non-deliberate behaviour, they can go to 4 to 6 years depending, but they cannot assess beyond that. So it's just a warning really, because HMRC seem to be behaving a little bit outside the rule book at the moment.